बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलुल्लाह वस्सलामु अलैका या हबीबल्लाह। प्यारे व्यूवर्स, उम्मीद करता हूँ आप तमाम दोस्त सब खैरियत से होंगे। अल्लाह ताला आप तमाम दोस्तों को सेहत के साथ लंबी ज़िंदगी अता फरमाए। मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी नई आने वाली वीडियो आप तक पहुँच सके। आज हम शुरू करते हैं, अपनी सीरीज़ का आगाज़ करते हैं। स्कोप। By no stretch of imagination, this section can be read to cover riding of a house to surprise any person engaged in sex. It deals with search for a thing necessary for investigation where there is no time for taking out a warrant under section 96 CRPC. Here also compliance with requirements laid down in section 103 CRPC is mandatory. PLD 1998, LH 35 1999, MLD 1618, law permitting an official to enter a house, e.g. for the purpose of making an arrest or to make a search, no violation of Article 14 of the Constitution. PLD 1999, LAH 297, person not a thing. PLD 1999, LAH 297, grounds of belief that the thing required will be found necessarily be recorded by the police officer. PLD 1999, LH 297. Section 166. When officer in charge of police station may require an other to issue search warrant. Number 1. An officer in charge of a police station or a police officer not being below the rank of sub-inspector making an investigation may require an officer in charge of an other police station, whether in the same or a different district, to cause a search to be made in any place in any case in which the former officer might cause such a search to be made within the limits of his own station. Number 2. Such officer on being so required shall proceed according to the provisions of section 165, shall forward the thing found, if any, to the officer at whose request the search was made. Number 3. Whenever there is reason to believe that the delay occasioned by requiring an officer in charge of another police station to cause a search to be made and under subsection 1 might result in evidence of the commission of an offense being concealed or destroyed, it shall be lawful for an officer in charge of a police station or a police officer making an investigation under this chapter to search or cause to be searched any place in the limits of an other police station in accordance with the provisions of section 165, as if such place were within the limits of his own station. Number 4. Any officer conducting a search under subsection 3 shall forthwith send notice of the search to the officer in charge of the police station within the limits of which such place is situate, and shall also send with such notice a copy of the list, if any, prepared under section 103, and shall also send to the nearest magistrate empowered to take cognizance of the offence copies of the record referred in section 165 subsection 1 and 3. Number 5. The owner or occupier of the place search shall on application be furnished with a copy of any record sent to the magistrate under subsection 4, provided that he shall pay for the same unless the magistrate for some special reason thinks fit to furnish it free of cost. Section 167. Procedure when investigation cannot be completed in 24 hours. Whenever any person is arrested and detained in custody and it appears that the investigation cannot be completed within the period of 24 hours fixed by section 61, and there are grounds for believing that the occasion or information is well founded, the officer in charge of police station or the police officer making the investigation, if he is not below the rank of sub inspector, shall forthwith transmit to the nearest magistrate a copy of the entries in the diary hereinafter prescribed relating to the case, and shall at the same time forward the accused to such magistrate. Explanation number 2. The magistrate to whom an accused person is forwarded under this section may, whether he has or has no jurisdiction to try the case from time to time, authorize the detention of the accused in such custody as such magistrate thinks fit for a term not exceeding 15 days in the whole if he has no jurisdiction to try the case or send it for trial and considers further detention unnecessary, he may order the accused to be forwarded to a magistrate having such jurisdiction, provided that no magistrate of the third class and no magistrate of the second class, not specially empowered in this behalf by the provincial government, shall authorize detention in the custody of the police. Number 3. The magistrate giving such order shall forward a copy of his order with his reasons for making it to the session judge. Number 5. Notwithstanding anything contained in section 60 and 61 are herein before to the contrary, where the accused forwarded under subsection 2 is a female, the magistrate shall not accept in the cases involving qatl or dacoity supported by reasons to be recorded in writing, authorize the detention of the accused in police custody, and the police officer making an investigation shall interrogate the accused referred to in subsection 1 in the prison in the presence of an officer of jail and female police officer. Number 6. The officer in charge of the prison shall make appropriate arrangements for the admission of the investigation police officer into the prison for the purpose of interrogating the accused. Number 7. If for the purpose of investigation it is necessary that the accused referred to in subsection 1 be taken out of the prison, the officer in charge of the police station or the police officer making investigation not below the rank of sub inspector shall apply to be magistrate in that behalf, and the magistrate may for the reasons to be recorded in writing permit taking of accused out of the prison in the company of a female police officer appointed by the magistrate, provided that the accused shall not be kept out of the prison while in the custody of the police station, police between sunset and sunrise. Commentary: Power of magistrate to discharge accused. There is a controversy on the point whether the magistrate has jurisdiction to discharge the accused when a remand is being sought under this section. One view is that magistrate is competent to make the order of discharge if he is of the view that there is no sufficient cause for granting the judicial remand 1985 PCR LJ 244 LH mere accusation against an accused in the FIR would not make such person as an accused within the meaning of criminal procedure code until some evidence implicating such person in the commission of offences available 1983 PCR LJ 298 AJ and K. Neither arrest of the accused had been shown in the case diaries nor any case diary recorded incorporating any incriminating material against accused till he was produced before magistrate for physical remand order of discharge of accused after examining case diaries can correctly be recorded by a magistrate 1999 PCRLJ 2241. Such order is analogous to one under section 3 at CRPC and an administrative order not susceptible to interference is divisional jurisdiction 1989 PCRLJ by 41. However, each case has to be decided on its merits. It is to be carefully seen whether the FIR contains a bald occasion of an offence or the same is substantiated through an evidence. Magistrate, without saying a word about the ocular evidence available on record, cannot declare an accused to be innocent on the basis of some affidavits produced in evidence during investigation without waiting for the finalization of investigation 1997. MLD 1135. It is held in Muhammad Wasim versus Additional Session Judge 1985 PCRLJ 244 that an order under Section 3 Act does not amount to the cancellation of the case, nor does it deprive the IO of his power to continue with the investigation of the case. In this case, it is also laid down that order under Section 3 Act CRPC as an administrative order and is not open to revision. This case was followed in 1989 PCRLJ by 41. IO can proceed with investigation and if there is material warranting the arrest of the accused, he should apply for permission to the magistrate to rearrest the accused and चालान him 1994 PCRLJ 1806. However, there is no bar for the police to rearrest the accused so discharge on some evidence or material being available in the connect connect him with the commission of offense 1995 PCRLJ 1575 1994 PCRLJ 1806 remand ordered by magistrate having no territorial jurisdiction not in accordance with law PLJ 2000 LH 1296 special order passed by magistrate on report of a police officer praying for discharge a special order of magistrate PLJ 2001 SC 817 if a magistrate has no jurisdiction to try an accused produced before him for remand, he can authorize the detention, but he considers the detention unnecessary. He can order the accused to be forwarded to a magistrate having such jurisdiction 2005 PCRLJ 1403. नंबर 2 स्पेशल order passed by magistrate on report of a police officer praying for jurisdiction special order of magistrate PLJ 2001 SC 817 if a magistrate also no jurisdiction to try an accused produced before him for remand he can authorize the detention but if he considers the detention unnecessary, he can order the accused to be forwarded to a magistrate having such jurisdiction 2005 PCRLJ 1403. Number 3. Grant of bail. The section does not empower the magistrate to grant in case exclusively terrible by Session Code NLR 1999 CR MUL 18. Number 4. Police asking for remand. Police asking for physical remand of accused for recovery of some incriminative material. Magistrate under section 167 has only two options, either to grant remand or to decline. Has no authority or jurisdiction to take cognizance and discharge the accused of an offense exclusively terrible by Session Code 2000 PCRLJ 43 PLJ 1996 LH 680 principles and laid down in Ghulam Sarwar's case 1994 PCRLJ 2588 detailed 2000 MLD 19 MLD 921. Grant of physical remand is connected with territorial jurisdiction. Physical remand to be granted either by area magistrate or in his absence by duty magistrate. Territorial jurisdiction to be given supreme consideration to set the law in motion. 2000 PCRLJ 1576. Such an order must be passed with all seriousness, keeping in view the relevant law. Instructions about grant of remand to police custody incorporated in chapter of police rules 1934 2000 PCRLJ 1576 magistrate while granting remand under section 167 CRPC should bear in this mind that a police officer arresting a person unjustifiable or otherwise than on a reasonable ground is guilty of an offense punishable under PPC 1993 PCRLJ 91 grant or refusal must be by positive application of mind PLD 1999 PESH 39 accused challenged and remand to uh, judicial custody. Police cannot take away his custody 1993 PCRLJ 221 duty of the court to inform accused about the grounds of his arrest. Accused has a right to oppose his remand and also ask for his release on bail. 1993 PCRLJ 2066 PLD 1993 PES 252 SH 252 granting of remand is a judicial function. Reasons for remand having to be stated in the remand order 1993 PCRLJ 2066 report under section 160. CRPC is not binding on the court 1995 KLR CR cases 453. Once challan is submitted in the court under section 173 CRPC, the provisions of section 169 CRPC cannot be invoked. 2000 PCRLJ 25 offense under section 380 suspects to be remanded to police custody of affecting recovery and should not be refused on the ground that material on record does not show that stolen property was in possession of accused and complainant has not disclosed his source of knowledge 2004 YLR 447. Magistrate duty bound to satisfy himself before deciding the matter of remand PLD 2005 SC 835. Number 5. Second remand of accused. Second remand an independent transaction 1991 PCRLJ note 88 P63 if an accused after having been challenged has been remanded to judicial custody by the trial court for being produced on the next date, police cannot take away his custody from jail without taking permission from the said trial court 1993 PCRLJ 221. Accused once sent to judicial custody cannot be handed over to police for subsequent and successive remand 1997 PCRLJ 1204. Number 6. Self-prepared printed form. Use of self-prepared printed form is grossly illegal. Legal remand order should be comprehensive, showing application of judicious mind PLJ 2003 CRC PES H 348. Number 7. Order refusing physical remand. Of accused. Police recommending discharge of accused having been found innocent irrespect of nomination of in FIR and linked by PWS magistrate is not bound to agree with the police report or with the conclusions conclusion reached by the IO. Law does not prevent magistrate to take cognizance under Class B of Section 190 CRPC. In spite of police report PLD 1960 SC 425, accused a fugitive class B of section 190 CRPC in spite of police report PLD 1960 SC 425, accused a fugitive class B of 190 CRPC in spite of police report PLD 1960 SC 2425, accused a fugitive from law section 169 cannot be pressed into service further once challan is submitted to the court under section 173 CRPC. The provision of section 167 CRPC cannot be involved. Those are PCRLJ 25. Number 9. Reinvestigation by police. If the police feels expedient to reinvestigate the case, the right course is to get discharge order passed by magistrate, set aside or seek permission of the court to reopen the case. Court would be justified not to take cognizance of the case case on a subsequent police report without adopting right course. Those are PCRLJ 580. Number 10. Discharge under section 163 remands. Number 1. Writ petition order of discharge under this section can be challaned in a high court under constitutional jurisdiction to declare it without lawful authority and of no legal court under no legal effect. PLD 1997 SC 339. High Court may direct the police to submit the challan in the court of competent jurisdiction. 2000 PCRLJ 425. Magistrate not competent to discharge the accused while exercising power under section 163(7). Order of the discharge quashed 1999 MLD 1847 and law notes 847 PLJ 1998 LAH 1683. Magistrate should not discharge accused on extraneous and irrelevant consideration as to close the scope of police to move for further investigation. PLD 1998 LH 513. Number 2. Application under section 561 A CRPC. Order of discharge under section 167 can be impugned before High Court under inherent jurisdiction under section 561A if passed in abuse of the process of law. 2000 PCRLJ 520. Number 3. Complainant party is left free to institute a complaint on the same facts and the same magistrate who does not become factious officio after the passing of order of discharge. PLD 1985 SC 62 1993 SCMR 187 1999 SCMR 304 1503. Number 4. Revision such order is analogous to one under section 3 CRPCA and an administrative order not susceptible to interference in revisional jurisdiction 1999 PCRLJ 2241। सेक्शन 168 इंशाल्लाह कल पढ़ेंगे। तब तक के लिए मुझे इजाज़त। अल्लाह हाफिज़।